If you obtained U.S. citizenship through the naturalization process and recently you've been staying up at night thinking, is it possible for this to be revoked? You aren't the only one. You observe the news stories. You watch the enforcement video coverage. You listen to the phrases enforcement surge, removal proceedings, immigration reform, and immediately something that previously seemed secure begins to seem uncertain. You earned this achievement. You prepared for the citizenship examination. You cleared the official meeting. You appeared in a federal chamber and recited the pledge. You trusted that occasion represented security, completion, legal protection. So, when immigration enforcement fills the media coverage in February 2026, it makes sense to wonder, have any regulations changed regarding my citizenship? Is citizenship obtained through naturalization truly permanent? Might enforcement measures potentially affect me? In this discussion, we're going to distinguish anxiety from reality, news coverage from legal framework, and assumptions from established constitutional principles. Because there's a significant distinction between increased enforcement presence and genuine legal jeopardy to your citizenship, and recognizing that distinction transforms your entire perspective. Hello, I'm Sophia, and welcome to U.S. Updates. My content focuses on explaining immigration regulations clearly, objectively, and accurately, particularly during periods like this when concern multiplies faster than reliable information. In this presentation, we're going to examine methodically what immigration enforcement policy in February 2026 actually signifies for naturalized Americans, what constitutional law guarantees, what citizenship revocation truly involves, and what it doesn't involve, and the reasonable actions you should or shouldn't consider currently. This isn't about partisan positions. It's about legal principles, protections, and accurate information. After watching this, you'll understand precisely your legal standing, what remains protected, and what you can reliably stop being concerned about. And that accurate understanding matters more than ever. Let's begin with the fundamental principle, because once you comprehend this clearly, much of the concern begins to diminish. According to the United States Constitution, citizenship once legally conferred is perpetual. That's not political rhetoric. That's not influenced by which administration governs. That is constitutional doctrine supported by Supreme Court precedent extending back many decades. If you finished the naturalization procedure, satisfied the resident standards, completed your citizenship and language tests, provided the necessary information, and recited the oath of allegiance, you are a United States citizen possessing the same constitutional safeguards as someone native-born in this nation. Your citizenship isn't temporary authorization. It isn't a permanent resident card. It isn't provisional standing. It doesn't require periodic renewal. It doesn't have an expiration date. And it can't be removed simply because immigration enforcement grows more intensive or political administration changes its approach. Presidential directives cannot supersede constitutional safeguards. Changes in enforcement approach cannot rewrite constitutional amendments. Legislative bodies cannot enact ordinary legislation that suddenly removes lawfully naturalized Americans from their standing. Citizenship, once correctly conferred, isn't vulnerable. It represents one of the most robust legal positions that exists in United States law. Now, I want to pause here momentarily because this is significant. Many individuals unconsciously transfer the concern they experienced as permanent residents into their existence as citizens. As a permanent resident cardholder, your standing could be challenged under specific circumstances. There were limitations, there were potential issues, there were maintenance obligations and movement restrictions. Citizenship is fundamentally different. It is conclusive. It is a constitutional standing, not an administrative designation. And if this type of straightforward, evidence-based explanation is valuable to you, make sure you're following this channel so you don't have to depend on speculation or online forum discussions the next time immigration fills the news headlines. Reliable information is one of the most effective forms of security you possess. However, and this is where we need to be exact, there is one limited legal exception that individuals often encounter without completely comprehending it. It's called citizenship revocation. And this term alone generates anxiety because it sounds like the government can simply reverse citizenship. That's not what it represents. Citizenship revocation is a formal judicial procedure that can only occur in federal court and only under very particular conditions. The government must demonstrate that a person acquired citizenship through deception or by intentionally hiding a significant fact during the naturalization procedure. This is not about political viewpoints. It's not about switching political affiliations. It's not about opposing the government. It is about whether the initial naturalization was legally proper. To satisfy that requirement, prosecutors would have to present evidence that someone intentionally provided false information on their naturalization application, concealed serious criminal background that would have rendered them ineligible, employed a fraudulent identity, hid participation in human rights violations or terrorism, or failed to disclose information that was legally significant to the approval determination. And even then, it is not instantaneous. The government must initiate a civil legal action. The individual has the entitlement to legal counsel. There is fact-finding. There are proof requirements. There is a judicial officer. The evidentiary threshold is substantial. And throughout history, citizenship revocation cases are uncommon, resource-intensive, and costly. They are not widespread administrative measures. They are case-by-case court processes that frequently require years to conclude. This differentiation matters tremendously in 2026 because when individuals hear about intensified immigration enforcement, some presume that citizenship could potentially be included into that enforcement effort. But citizenship revocation is not a procedural mechanism that can be broadened carelessly. The legal requirement has not been modified. There has been no new legislation changing the evidentiary threshold. There has been no Supreme Court decision diminishing constitutional safeguards for naturalized Americans. Even if an administration desired to pursue citizenship revocation cases more vigorously in instances of demonstrated deception, it would still be constrained by the same constitutional obligations and procedural protections that have existed for many decades. So when you encounter the expression removing citizenship, recognize that in actuality it references a limited court-controlled procedure connected to deception, not a political instrument that can be activated against law-following naturalized Americans. So, if naturalized citizenship is constitutionally safeguarded and citizenship revocation is uncommon and deception-based, what precisely is occurring currently in February 2026 that's making so many individuals anxious? The explanation is enforcement prominence. The current administration has substantially expanded immigration enforcement activities. Immigration Enforcement Agency activity is more regular and more publicized. Custody regulations are more stringent. Border enforcement has strengthened. Deportation initiatives are being emphasized for individuals who lack lawful status or who have final deportation judgments. That change in prominence alters how communities perceive, even if it doesn't alter the legal circumstances for citizens. When you observe workplace enforcement covered on the media, when you learn about extensive removal activities, when social platforms amplify every enforcement incident, it generates the perception that the entire immigration system is unstable. But here's the essential differentiation. Enforcement measures target immigration standing infractions. Naturalized Americans do not have an immigration standing. You have citizenship. You are not in the classification of individuals subject to deportation processes. You do not require temporary authorization. You do not require to renew anything. Your legal connection with the United States is fundamentally distinct from someone who lacks lawful status or even someone who is a permanent resident. This is where misunderstanding multiplies. Immigration regulation discussions often get characterized broadly. Enforcement against foreign nationals, strict immigration transformation, new deportation initiative, but those expressions combine multiple legal classifications into one emotional news story. A permanent resident cardholder is not identical to an undocumented foreign national. A temporary authorization holder is not identical to a naturalized American. Enforcement directed at unlawful presence does not legally reach to individuals who have finished naturalization. Yet, when language becomes severe, individuals who spent years managing a precarious immigration system can instinctively feel like that precariousness has returned. It hasn't. The language may be more severe. The enforcement may be more prominent, but language is not legal framework. Prominence is not a constitutional revision, and severity does not rewrite citizenship safeguards. Now, let's address 3 of the most frequent assertions circulating currently, because false information flourishes in situations like this. The first assertion is that widespread citizenship revocation is approaching, that the government is preparing to remove citizenship from substantial numbers of naturalized Americans. There is no legal procedure for this. There is no new statute authorizing it. There has been no constitutional modification permitting it. Citizenship revocation, as we examined, requires case-by-case federal court processes connected to deception. It cannot be implemented in large quantities through administrative measure. The second assertion is that specific nationalities or faith groups are being singled out for citizenship removal. While immigration enforcement emphasis can concentrate on specific geographic areas or security issues, citizenship revocation cases must be founded on deception or significant false representation, not race, faith, ethnicity, or political perspective. Singling out citizenship removal based on those characteristics would be unconstitutional and immediately contested in federal court. The third assertion is that naturalized Americans need to take immediate extreme measures to safeguard their citizenship. Abandoning previous citizenship immediately, submitting special documentation, purchasing protection programs, or enrolling with organizations offering guarantees. None of that is required. Your citizenship is safeguarded by the Constitution, not by supplemental submissions or commercial programs. Anxiety-driven businesses often appear during periods of uncertainty. Be skeptical of anyone requesting you to provide money to protect something that is already legally protected. Comprehending what is genuinely occurring and what is not alters how you react. There is a genuine enforcement change in 2026. There is an increased concentration on undocumented standing. There is political severity around immigration, but none of those developments modify the constitutional perpetuity of lawfully acquired naturalized citizenship. When you distinguish enforcement appearance from legal power, the situation becomes much more transparent and much less alarming. Now that we've distinguished legal circumstances from political atmosphere, let's transition into something actionable. Not because your citizenship is in jeopardy, but because accurate understanding becomes even more beneficial when you know what to do next. The first action is straightforward. Protect your official records. Keep your naturalization document in a protected place. Make physical duplicates and, if feasible, secure electronic copies stored safely. This is not because someone is coming to challenge your citizenship at random. It's because having quick access to verification eliminates concern if you ever need to request a passport, substitute documents, sponsor a relative, or confirm your standing for any purpose. Preparation reduces concern. The second action is comprehending your entitlements as a citizen. You have complete constitutional safeguards. You have the entitlement to procedural fairness. You cannot be deported. You can journey on a United States passport. You can participate in elections. You can sponsor relatives. These entitlements are not theoretical. They are legally enforceable. Sometimes, simply reviewing what citizenship legally provides you restores a sense of security that news coverage can temporarily undermine. Third, if you have relatives who are lawful permanent residents and qualified for naturalization, this is a significant moment to consider recommending them to apply. Permanent residence is substantial, but it is not identical to citizenship. Permanent resident cardholders can still be entered into deportation processes under specific circumstances. They must preserve residence obligations. They are subject to immigration enforcement regulations in ways citizens are not. Naturalization provides conclusiveness. The procedure itself has not fundamentally altered in 2026. It still demands physical attendance, sustained residence, English capability, citizenship understanding, and proper moral standing. But if someone in your household qualifies, pursuing citizenship can provide sustained security that is particularly valuable in an enforcement-intensive environment. If this explanation is helping you think more rationally about your circumstances or your household's alternatives, consider forwarding this video with someone who might be silently concerned but hasn't raised these questions openly. Sometimes accurate understanding spreads one discussion at a time. Now, let's discuss more challenging household scenarios, because this is often where concern really exists. If you have undocumented relatives, the current situation is not beneficial for disregarding that circumstances. Enforcement is operational. Deportations are happening. Undocumented standing carries genuine precariousness, and wishing that prominence will decrease is not a plan. That doesn't mean anxiety, it means professional consultation. There may be options someone hasn't investigated: status adjustment through relatives, protection-based remedies, exception requests, deportation cancellation, or other assistance depending on the circumstances. But those alternatives are situation-specific and require a certified immigration legal professional to assess correctly. Speculation and online recommendations are risky in this environment. If you are sponsoring a relative internationally, recognize that family-based immigration remains permissible, but handling durations may extend, examination may intensify, and regulatory modifications could affect classifications or numerical limits. Postponing unnecessarily can sometimes mean encountering more stringent requirements later. And if you journey internationally as a naturalized American, always journey on your United States passport. The United States acknowledges dual citizenship, but some nations do not. If you visit to your nation of origin, be cognizant of that nation's regulations regarding dual nationality, revenue collection, or service obligations. None of those matters affect your United States citizenship, but they are realistic considerations worth comprehending before you journey. What all of this amounts to is this: your citizenship itself is secure, but your household's immigration circumstances may still require consideration. Security at the highest level does not mechanically protect every level beneath it. Being forward-thinking, not anxious but forward-thinking, is the most productive reaction to a high enforcement situation. At this stage, you might be raising a very realistic question: do I need an immigration legal professional currently? And for most naturalized Americans with uncomplicated backgrounds, the response is no. If you acquired your citizenship lawfully, provided required information truthfully, and have not been approached by the government regarding deception or false representation, there is no preventative legal submission you need to complete. There is no special protective action required. Citizenship does not need upkeep. It does not need periodic renewal. It does not demand protective documentation. However, there are specific circumstances where consulting an immigration legal professional makes sense. If you are sponsoring a relative and the case includes previous overstays, deportation judgments, criminal background, or complicated exception requests, you absolutely want professional assistance. If you have undocumented relatives attempting to evaluate their alternatives, that assessment must be case-specific. If you ever obtain formal correspondence from Federal Immigration Services, the Department of Justice, or any federal organization challenging previous immigration statements, that is the occasion to obtain counsel immediately. And when I say legal professional, I mean a certified immigration attorney, someone authorized to practice law, ideally concentrated specifically on immigration matters, and preferably affiliated with credible organizations such as the American Immigration Lawyers Association. Be skeptical of anyone who promises results. Be skeptical of substantial cash requirements without documented contracts. Be skeptical of non-attorneys or advisors representing themselves as legal professionals when they are not authorized to practice law. Immigration deception increases in periods of uncertainty because anxiety generates vulnerability. A genuine legal professional will assess your circumstances, communicate risks transparently, and never guarantee unachievable results. They will not tell you they can safeguard already protected citizenship for payment. They will not create emergency submissions that do not exist. Legal assistance should diminish concern, not take advantage of it. Now, I want to transition to something that doesn't appear in laws or court decisions, but is very genuine: emotional history. Many naturalized Americans carry years, sometimes many decades of immigration-related concern. You may recall what it felt like to await authorization approvals, to monitor case conditions online constantly, to worry about overlooking a document, to fear that an error could jeopardize everything. That mental impression doesn't vanish immediately just because you obtained a certificate of naturalization. So, when enforcement news stories increase, even if your rational mind comprehends that your citizenship is protected, your emotional response may react distinctly. You might experience a moment of the previous precariousness. You might challenge something that is legally resolved. That response doesn't mean you miscomprehend the law. It means you experienced through uncertainty for an extended time. It's significant to acknowledge yourself for that experience. You managed a complicated legal system. You satisfied the standards. You obtained citizenship lawfully. The concern you once experienced was logical in previous phases of your immigration procedure, but the legal circumstances of your standing has altered. You are no longer in a conditional classification. If you discover that the current political environment reactivates previous anxieties despite knowing the legal circumstances, consider connecting into community. Communicate with other naturalized Americans who share comparable experiences. Associate with immigrant support organizations that provide reliable updates. If concern feels significant, there is no deficiency in obtaining counseling assistance to address it. Security is not only a legal state, and it's also a mental one, and both matter. As we examine the larger situation in February 2026, it's significant to distinguish two forces that often get combined together: political environment and constitutional framework. Political environment can change quickly, enforcement emphasis can strengthen, public language can become more intense, media reporting can magnify every measure, but constitutional framework moves gradually, methodically, and with substantial obstacles to modification. Citizenship belongs to that framework classification. It is established in constitutional amendments and strengthened by many decades of Supreme Court precedent. That establishment does not shift with each electoral period. So when you encounter comprehensive language about immigration enforcement surges, recall that those regulations function within legal classifications: undocumented standing, authorization infractions, deportation judgments, asylum qualification. Citizenship is a distinct classification entirely. If you naturalize lawfully and truthfully, there is no concealed procedure waiting to reverse that. There is no presidential shortcut. There is no silent administrative action. There is no new 2026 law that has rewritten the regulations of citizenship revocation. The legal requirement remains deception or intentional hiding of significant fact demonstrated in federal court with complete procedural protections. Here's what we know transparently. Immigration enforcement in 2026 is prominent and operational. Deportations of undocumented individuals are taking place. Border and custody regulations have intensified. Regulatory discussions around asylum, employment authorizations, and family-based immigration persist. But none of those developments modify the perpetuity of lawfully acquired naturalized citizenship. If you responded your application truthfully, provided what you were obligated to provide, satisfied qualification standards, and recited the pledge, your citizenship is protected under the Constitution. That is not wishful thinking, it is legal reality. So the path ahead is not anxiety, it is knowledge. Stay updated through dependable sources like Federal Immigration Services, the State Department, credible legal organizations, and certified immigration legal professionals. Keep your official records arranged. Recommend qualified relatives to naturalize. Obtain professional recommendations when cases are complicated. And most significantly, permit yourself to exist in the security you obtained. You have the entitlement to participate in elections. You have the entitlement to possess a United States passport. You have the entitlement to sponsor relatives. You have the entitlement to reside here without fear of deportation. Those entitlements are not theoretical. They are legally enforceable constitutional safeguards, and comprehending them completely is one of the most effective reactions to an intense political situation. If this video has helped you feel more informed about what naturalized citizenship actually safeguards and what it does not, make sure you follow U.S. Updates. We're dedicated to evidence-based immigration assistance that eliminates false information and concentrates on what the law actually states. Forward this video with someone who might be concerned but hasn't had access to reliable information. And if there's a particular assertion you've encountered or a subject you want us to address next, mention it in the comments. Your questions help develop future videos that address genuine concerns in our community. Thank you for watching, and thank you for being part of a space where reliable information is considered as security, not partisan politics.